All right, CA Inter students, let's talk about a chapter that's a huge deal for your exams, the LLP Act 2008. We're going to skip the fluff, focus on exactly what you need to know, the exam hotspots, so you can walk in there feeling totally confident. Let's do this. Okay, let's start with a nightmare scenario. Picture this. You and a friend start a business. It's your dream. But then your partner messes up. Big time. The business is drowning in debt. And now the creditors aren't just taking the office furniture. They're coming for your car, your house, your personal savings. Can that actually happen? You bet it can. For a very long time in India, this was a very real and very scary possibility. So that nightmare we just talked about, that's the ugly truth of what we call unlimited liability. And for years, if you wanted to start a business in India, you had this horrible choice. Either you go for a partnership and risk literally everything you own, or you dive into the super complex, super expensive world of starting a company. It was a tough spot to be in, and everyone knew we needed a better way. And this right here, this is that classic dilemma in a nutshell. Look, on one hand, you've got the traditional partnership. It's simple, it's flexible, which is great, but the liability? Unlimited. Your personal assets are on the line. Then you've got the company. Yeah, your liability is limited, your house is safe, but the compliance? Oh man, it's a mountain of paperwork, super costly, and really rigid. So the big question was, isn't there something in between? A sweet spot? And that's where this new rulebook comes in. Parliament stepped in to create that perfect middle ground, that third option that was desperately needed. And that's the Limited Liability Partnership Act of 2008. Okay, let's get the basic facts down, the stuff you just gotta know. The bill passed Parliament in December 2008. It got the president's official okay, the assent, in January 2009. The whole act is made up of 81 sections and 4 schedules, and we'll talk about those schedules in a second. And super important, this law applies to the whole of India, no exceptions. Now, those 4 schedules I mentioned, think of them like instruction manuals. The first schedule is basically your default settings. If you and your partners don't create your own LLP agreement, the law says, no problem, just follow this one. The other 3, second, third, and fourth, are basically conversion kits. They give you the step-by-step guide on how to change a traditional partnership firm, a private company, or even an unlisted public company into an LLP. So who's in charge of all this? Well, it's the Ministry of Corporate Affairs, the MCA, and the Registrar of Companies, the ROC. And the central government is the one that can make new rules. Okay, now listen up, because this is a point where so many students lose marks. I'm serious. The Indian Partnership Act of 1932 does not apply to LLPs at all. I'll say it again. The Partnership Act does not apply. LLPs are governed only by the LLP Act 2008. And yeah, it was recently tweaked a bit by the Amendment Act of 2021. Which brings us to a really good question. Why? Why create a whole new law? Why not just change the old ones? The answer is pretty simple, actually. It was all about creating something that truly gave you the best of both worlds. You see, the goal wasn't to get rid of partnerships or companies. It was to create a brand new option, a real alternative. Especially for all the professionals out there. You know, chartered accountants, lawyers, architects, consultants. This whole service sector is a massive part of India's economy, and they needed a business structure that fit them perfectly. And this quote right here really nails it. The whole idea was to let professionals team up to combine their expertise with that entrepreneurial spirit, but in a way that's flexible and efficient. It's about letting people take smart risks and build amazing things without that constant fear of, what if I lose my house? All right, so we've totally covered the why behind the LLP Act. Now, let's get into the what. I keep using this word hybrid, but what on earth does that actually mean? What is an LLP, really? Okay, think of it like this. An LLP is a hybrid. It's like it went shopping and picked the best feature from a company, which is limited liability, and the best feature from a partnership, which is flexibility. You get the safety of a company, but you get to run the inside of your business with the freedom of a partnership, based on your own agreement. It's a legal entity, but it feels like a partnership to run. Let's break down the key features, because this is gold for your exams. First, and this is so important, an LLP is a separate legal entity. It's its own person in the eyes of the law. It can own property, it can sign contracts, it can sue someone. Second, the LLP itself is responsible for its own debts. But here's the magic, the whole point of it all. The partner's liability is limited. It's limited to whatever they agreed to contribute. The creditors can't come after your personal car or house. That's the game changer. And as a bonus, the compliance is way less of a headache than with a company.
Okay, we're heading into the final stretch now, and honestly, this might be the most crucial part for your exam. We're talking about the definitions. Knowing the exact legal language of the Act is non negotiable. ICAI questions are full of these, so let's lock them in.
First up, the term body corporate. The starting point is simple. It means a company, like one defined in the Companies Act. But that's too easy, right? The real test, where you get the marks, is in what the LLP Act adds to this definition and what it specifically kicks out.
So, for the purposes of the LLP Act, the term body corporate also includes an Indian LLP, a foreign LLP, and a company from outside India. Simple enough. Now for the trap. Here's what it is not. A body corporate does not include a corporation sole, and this is the big one. It does not include a cooperative society. Let me say that again, because this is where marks are lost all the time. A cooperative society cannot be a partner in an LLP. Why? Because it's not considered a body corporate under this specific law. This is a classic ICAI trick question, perfect for an MCQ or a case study. Burn this into your memory. Okay, next definition, financial year. The basic rule is exactly what you'd expect. It runs from the 1st of April of one year to the 31st of March of the next year. Standard stuff. Seems easy, right? Well, hold on. Of course there's a twist. This is company law, after all. And this is an exception that ICAI loves to ask about. So, what happens if your LLP is born late in the year? Let's say it's incorporated anytime after the 30th of September. The law is actually pretty practical here. It says, hey, it's a pain to close your books after just a few months. So you get an option. Your first financial year can end on the 31st of March of the year after the next one. So for example, you incorporate on, say, October 15th, 2022. Your first financial year doesn't have to end in March 2023. You can choose to extend it all the way to March 31st, 2024. And what does that mean in terms of time? It means that in this special case, your first financial year can actually be as long as 18 months. That's a key number to remember for any practical questions they might throw at you. Up to 18 months. Okay, let's wrap up with a quick lightning round on a few other definitions. Address, simple. For a person, it's their home address. For a body corporate, it's the registered office. Business. The definition is huge. It includes basically any trade, profession, or service. Designated partner, that's a specific partner who's officially responsible for compliance. Entity usually means a body corporate, but for certain rules, it can also include a regular partnership firm. And finally, a foreign LLP, that's just an LLP that was formed outside India, but has a place of business right here. Think about that for a second. The whole reason LLPs exist is for limited liability, right? But ICAI loves to test the exceptions. What if that one core principle, that safety net you thought you had, could just disappear? Stick with me, because we are going to uncover exactly how and when that limited liability shield can be completely shattered. Okay, here's a classic exam-style problem. It seems straightforward, but it pulls in ideas about agency, liability, and compliance all at once. So who's on the hook? Is it Rohan, the LLP, the other partners? The answer is buried in the sections we're about to dissect. This isn't just theory, my friends. This is how you score those crucial marks. All right, let's start with the absolute foundation of the LLP structure. Seriously, understanding the relationship between a partner, the LLP, and the other partners is everything. If you get this right, the rest of the chapter just clicks into place. Now, this is so important. Section 26 gives us this critical distinction. A partner is an agent of the LLP itself. That means their actions can bind the whole LLP. But, and this is the game changer compared to a traditional partnership, they are not agents of the other partners. This separation is the very heart of limited liability. ICAI loves to set tricky questions on this, so please burn this into your brain. An agent of the LLP, yes. An agent of the other partners, no. So just how far does this liability go? Well, sections 27 and 28 spell it out. The LLP is liable for its own debts, but only using its own assets. A partner's personal house, car, bank account, they're safe. But here is the exam trap you absolutely have to watch out for. That shield does not protect a partner from their own wrongful actions. If you mess up personally, you are personally liable, period. Okay, now let's get into the interesting stuff. The situations where that liability shield can get some serious cracks in it. This next section on fraud and holding out is where the consequences get really severe, so pay close attention. And this brings us right back to our man Rohan from the exam problem. Section 29, holding out, is the key. If any person, either by their words or their actions, lets a third party think they're a partner, and that third party then gives money or credit to the LLP because of that belief, well, that person is now personally on the hook. The LLP is also liable, but only for the credit it got. Just a quick side note, this rule does not apply to the estate of a partner who has passed away, even if the business keeps using their name.
And here it is, the answer to that question I asked at the very beginning. Section 30 is the nuclear button. If any act is done with the intent to defraud creditors or for any fraudulent purpose, that limited liability shield doesn't just crack, it vaporizes. The liability of the LLP and every single partner involved in that fraud becomes unlimited. But wait, there's more. Anyone who is knowingly a party to it can face up to 5 years in prison and a massive fine. And on top of that, they have to compensate anyone who lost money. So the takeaway is simple. Fraud absolutely destroys limited liability. This section is a huge deal for your exam.
Now, because the penalties for fraud are so harsh, the Act has a kind of safety valve in Section 31. This is the whistleblower provision. It's designed to protect partners or even employees who step up and report misconduct. If you provide useful information, you can't be fired, demoted, suspended, or harassed for it. Better yet, if your information helps an investigation, a court can even reduce or completely waive any penalty you might have faced yourself. It's all about encouraging people to do the right thing.
Okay, let's switch gears. We've talked a lot about liability. Now let's talk about the money. What partners put in and what the LLP has to report. This is all about compliance, and trust me, marks are so easily lost on the little details and deadlines here.
So a partner's contribution doesn't just have to be cash. Section 32 is clear. It could be property, know-how, even services. But here's the crucial point for creditors under Section 33. A partner's promise to contribute is a serious obligation. Let's say a partner promises to bring in 10 lakhs. A bank lends the LLP money based on that promise. The partners can't just secretly agree later to reduce that contribution to 5 lakhs. That creditor can still come and enforce the original 10 lakh promise.
Now for some super important compliance rules. Every LLP has to keep proper books of account using the double entry system. Every year, they must prepare something called a statement of account and solvency. Now, circle this in your notes. It has to be filed with the registrar within 6 months from the end of the financial year. That deadline is key. And accounts have to be audited unless the government says otherwise. Section 34A also gives the central government the power to set accounting standards, but they have to consult with the NFRA first. This next part is all about what you have to file every year and what the public can see. The deadlines and penalties we're about to discuss are a favorite area for ICII to ask very specific questions. So let's dial in. Okay, look very closely at this table. This is pure gold for exam questions. If you don't file that statement of account and solvency on time, the penalty is 100 rupees per day, and that hits both the LLP and the designated partners. For the LLP, the penalty is capped at 1 lakh. For each designated partner, it's capped at 50,000. Now look at the annual return from Section 35, which has to be filed within 60 days of the year end. Notice something? The penalty is exactly the same. Same 100 rupees per day, same caps. This similarity is a classic ICAI trap, and please don't mix up these late filing fees with the much, much bigger penalties for not keeping proper books in the first place. Beyond the big annual filings, you also have to report any changes in the partners. Section 25 gives you a 30-day window to tell the registrar if someone joins, leaves, or even just changes their address. If you miss it, it's a flat penalty of 10,000 rupees on the LLP and on each designated partner. And hey, if a partner leaves and doesn't trust the LLP to file the form, they have the right to file it themselves. Finally, to keep things transparent, Section 36 says anyone from the public can pay a small fee and inspect the LLP's key documents. All right, let's shift our focus now to the regulator, the Register of Companies. What powers do they have? And how does the law handle offenses that go beyond just filing something late? Okay, this is a serious one. Section 37 is about lying on official documents. If a person knowingly makes a false statement or leaves out an important fact in any filing, the punishment is really severe. We're talking imprisonment for up to 2 years and a fine that can go all the way up to 5 lakh rupees. Notice I said and, not or. The court can hit you with both. You see, the registrar isn't just a place to file papers. Under Section 38, they have real investigative powers. They can demand information from anyone connected to the LLP, partners, employees, anyone. And if they don't like the answer they get, they can summon that person to appear before them. If you refuse to cooperate, you could be looking at a fine of up to 25,000 rupees. So, what if you've messed up and committed an offense? Section 39 offers a way out called compounding, but it only works for offenses where the punishment is just a fine. Think of it like a settlement. You apply to the registrar, they send it to the regional director, and the RD can agree to settle the matter for a certain sum of money. Once it's compounded, the case is closed. But, and this is a critical point for exams, there's a 3-year cooling off period. You cannot compound a similar offense if it happens again within 3 years of the first one.
All right, we're in the home stretch now. Let's finish up with 2 important structural topics: what happens when a partner wants to transfer their rights, and how other types of businesses can become an LLP.
Section 42 draws a really clear line in the sand. A partner can absolutely transfer their economic interest in the LLP, their right to get a share of the profits. But what they cannot transfer is their right to be involved in management. The person who gets the financial interest doesn't become a partner, they don't get a vote, and they can't look at the books. It's like selling your share of the lottery ticket winnings, but not your right to help pick the numbers.
One of the best features of the LLP Act is that it lets existing businesses convert into this structure. Under Sections 55 and 57, both traditional partnership firms and unlisted public companies can make the switch. And the best part, under Section 58, is that the transition is seamless. All the assets, all the debts, all the contracts, everything just automatically moves over from the old business to the brand new LLP. And that brings us full circle. Is an LLP's liability truly always limited? Well, by now, you know the answer is a big fat no. While limited liability is the general rule, that shield can be pierced by things like holding out, and it can be completely shattered by fraud. So, for your exams, know the rule, but master the exceptions. That is where you'll really show your understanding, and that's where the marks are. Best of luck with your studies.